Hi, everyone. I'm Nicole Hemrick, and I'm the founder and managing partner at Hemrick O'Malley PLLC. Today, I would like to tell you about a new policy memorandum issued by the EOIR, that's the Executive Office for Immigration Review, regarding the pretermission of legally insufficient asylum applications. This was issued on April 11th, 2025 by Acting Director Owen, and it was to provide guidance on the legal standards related to the pretermission and legal insufficiency in asylum applications. Among other things, the policy memo states that adjudicators may properly consider pretermission of a legally deficient asylum application, although the ultimate decision remains with the presiding immigration judge. This really isn't anything new. Immigration judges have had the authority to pretermit asylum applications before and have done so. I believe the reason this is happening is there has been some case law that permitted this back from the late 80s. Ultimately, the underlying regulations that were an issue in those prior cases are no longer in effect, therefore creating a bit of a gray area as to whether this is still permissible. Now, EOIR has clarified that it certainly is permissible. The EOIR seems to be resting its current policy on the fact that the Code of Federal Regulations at section 1240.11C3 says that a hearing on asylum is only required where there is a factual issue in dispute. The thought process here is if the application itself is legally insufficient, there may not be any factual issues in dispute. There's also other case law and other regulations which the EOIR rests on in order to justify its current policy. That being said, what does that mean for you? It means that you need to be really careful when you're filling out your application. You need to make sure that you've answered all questions in the application. You need to make sure that you've answered all questions in the application itself. On the last few pages particularly, there are boxes that call for more detail, and some of these questions have multiple embedded questions. For example, you will find that at page 5 of the I-589, the current edition says at 1A, have you, your family, or close friends or colleagues ever experienced harm or mistreatment or threats in the past by anyone? And then it goes on to say, if yes, explain in detail what happened, when the harm or mistreatment or threats occurred, who caused the harm or mistreatment or threats, and why you believe the harm or mistreatment or threats occurred. So what that means is there's actually 5 different questions being asked in the same question, and you must answer every single one, or there's a chance that an immigration judge may find that you haven't properly answered the question and consider your application legally insufficient, and therefore pretermit, that is, close out, deny your case before you've even had a chance to provide any testimony. Here's another question that I see gets a lot of people, okay? This is on page 7 of the I-589, question 2A. After leaving the country from which you are claiming asylum, did you or your spouse or children who are now in the United States travel through or reside in any other country before entering the United States? Then 2B asks, have you, your spouse, your children, or any other family members, such as your parents or siblings, ever applied for or received any lawful status in any country other than the one from which you are now claiming asylum? Finally, it says under those, if yes, to either or both questions 2A and or 2B, for each person provide the following: the name of the country and the length of stay, the person's status while there, the reasons for leaving, whether or not that person is entitled to return for lawful residence purposes, and whether the person applied for refugee status or for asylum while there, and if not, why he or she did not do so. So again, these questions are very detailed. They ask for a lot of information. In the past, some people would write, please see my statement for more information. I don't think that this is the time to be doing that. You need to make sure that you answer every single one of these questions on the application itself, perhaps using addendum pages if needed. And then, of course, your personal statement should have consistent information, perhaps elaborating on this information. Because now we are in an era where the EOIR is more empowered to pre-termit cases just on the face of the application, this is all the more reason it is extremely important that you hire a competent, licensed immigration attorney to assist you in your immigration case before the immigration court. If you have any questions about this or any other immigration matter, give us a call at 833-848-7838 or check us out online at www.hemrick.law.